appreciate it. We get kind of community leader. That's outstanding. I appreciate that. We're glad to be here. We've been members of the chamber forever and had a great experience with everyone. I appreciate your attention for this today. So my wife told me today, she's like, you and Russell, that sounds so boring. So I will do my best not to be boring, no offense, Ed. Right. She said you and Russell, not just me. So, so I love it if we can be as interactive as possible. So you have a freedom to ask a question. Anytime you can ask a question right now, or you can ask a question at any point throughout, and of course at the end we'll leave time for questions. And we'll stay after too if you want a private question after we're finished with the actual program. We'll each do a half hour or so on this. So, employment law and social media, both of those things did not exist when I started as a lawyer. I got out of law school and, social media was barely being invented back in the dark ages. And even employment law, there's always been labor lawyers, of course, with unions and everything. And as you know, in Western New York, the union presence is a little smaller than a lot of other areas of the country. Where I grew up in New York, it was a huge deal. But so lots of people call themselves labor lawyers, but nobody said I'm an employment lawyer. But of course now it's like 75% of my time. I'm in the litigation department, so I do employment litigation, but the employment law advice is a huge, huge topic. You may have heard the new sexual harassment regulations just to affect paid family leave in New York is a huge deal for a lot of us employers. So this is, a cutting edge topic. And what is social media? Well, I can guarantee you if my 4 high school, college, and older sons were here, they'd say, those are all obsolete, you're an idiot. There's 8 more you've never heard of. Like my wife says, hey, to one of them, did you see this on Facebook? And he's like, Mom, I don't use Facebook. This Facebook for the young. Even Instagram is largely gone. If you have kids, you'll know that. They have other things that are similar to Instagram, being horrible in that it disappears. But of course they take screenshots of it. So that will be one of the themes of this is everything out there, whether it's more traditional, voicemails, emails, texting, but all this social media stuff, it's never gone. It's just a question of how much money you got. So when I litigate a case, if my client or my opponent really wants to spend a lot of money, we can find everything that was ever on any of these. And the screenshot of Instagram that's allegedly gone is one of the biggest things because the person who sent it thinks it's gone and it's not gone. So all of these things are in it. They're all possible trouble areas for you as an employer. And I can tell you there's a whole subculture of every single company going on. We had many years ago a client that literally had like an entire revolution going on between the administrative assistants texting each other all day long, and when they end up going back and finding it was company phones, the company had a right to look at them. There was something like 1,500 texts sent in a single business day among the admins while they were allegedly working, and all the nasty stuff amongst each other. Nicknames of the bosses. It was quite entertaining, but it was a big problem. So it's something we all have to address, and we'd rather that we don't have to talk about it, but sometimes we do. So what surprises a lot of people about social media and the law, and this is more labor law obviously than employment law, is the NLRB is heavily involved in regulating this area. So you might think, hey, I don't have a union in my employment. What is the NLRB talking to me about? Well, the NLRA, which is the law that the NLRB enforces, the National Labor Relations Act, applies to everyone, even not unions. A lot of people just don't know that. So there's a whole bunch of law that we have to follow. So for example, if you went on obsolete Facebook or some other social media platform today, and it says on there, Keneally is the cheapest SOB I've ever met in my life. I hate them. Underberg doesn't pay us enough. Screw them. Period. Post. We might say, fire that person. And I can tell you probably 2/3 of my partners would say, Keneally, go fire them, they're gone. And I would say, I can't fire them because it's illegal, because it's about terms and conditions of employment, arguably. Much of it is ad hominem nastiness on the side. But the fact is that is legal. The employees are entitled to say that. And there's absolutely nothing you can do about it. It's very, very disturbing. I get calls monthly. Somebody wants to fire somebody for that, and you just can't. And that's just one example of many that the General Counsel has issued statements about policies that are that are illegal, that you can't have, and that's one of them. You can't do anything, any policy or any firing or disciplinary decision that prohibits or limits concerted activity using social media is illegal. So their mandate from long ago is not only unions, but anything akin to a union. Concerted activity, employees talking amongst themselves or expressing themselves about terms and conditions of employment is protected. And what some clever employers have tried to do is write a whole bunch of a whole bunch of actually fairly reasonable but strict policies about employee behavior, and then they put in the last sentence, oh, by the way, if anything of this is illegal under the NLRA, don't count that, but we'll do the rest of it. You can't do that. That doesn't work. It's a nice idea. I don't know where they got it, but, and then of course this is the key for us, for many of us, is it applies to non-unionized employers too. You know, in the union setting, they're used to all this. They have the collective bargaining agreement. There's frankly more avenues to express concern about wages and hours and conditions of employment. And frankly, they have the union reps make those arguments for them, so actually they're less likely to be on Facebook or other places making these comments, but either way it's protected in both. So some of the policies that employers quite reasonably think of and put into place, but that can cause them problems, are these. So one of them, do not release confidential information about employment or coworkers. So what does confidential information mean? Well, you can argue about that, what's confidential or not. One of the things that people think of is, hey, do not tell anybody what you make. That's confidential between you and me. Well, you can't do that. They're entitled to talk about their wages amongst themselves. And guess what? They all do. They all know what each other makes. There's no point in even trying to pretend that. I mean, we had one last year where one person in a small company said, hey, I'm going to leave, I want a raise. And so the HR person was talking to me about, you know, certain aspects of this person. They were concerned about them, but they had some good skills, some bad, you know. So they ended up giving them, you know, not all of it, but a good percentage of the raise, and literally called me back in like 90 minutes and said, I have 3 people banging at my door who want the money that she just got. Said, you know, she's like, I want to fire them all. I told them to keep quiet. I said, sorry, you can't do that. Or reveal non-public company information. That kind of blanket policy is legal. However, you know, if we have anybody, an IP type person in the audience, absolutely, that's absolutely properly protectable. Any sort of intellectual property that you have, you can protect with agreements and policies and otherwise. And that can apply not just to patents or trademarks, but all the way down to trade secrets, that anything that's unique about your company. But it can't be a term or condition of employment. That's the separating line. So the things that the NLRA would talk about is wages, benefits, you know, any other terms and conditions, office space, the size of your window, the view, you know, the employees are creative and complaining about all sorts of things. So all of those are protected. And you know, in terms of enforcement, we're fortunate here to be in a mid-sized city that we don't get a ton of NLRA, NLRB audits of things like this. But you should know it's out there, and you don't want to be the one example and the shining star on the cover of the DNC or the anywhere else of somebody went, you know, NLRB's right there in Buffalo, very good staff of smart investigators, so you don't want a complaint going there and you being the cover story. And pay and benefits are obviously the classic one that we all want to keep confidential as employers, but we can't. And by the way, if you ever want to ask an experienced HR person or an office manager type person, you know, just go into say, hey, you know, we're an XYZ business, and you know, we have a bunch of 30, 40-year-old, you know, mid-level, semi-experienced folks. You know, what do they make? Well, they make this and this and this here. They make this. I mean, there's no secrets. It's out. Everybody knows what the market is. So one of the big problems I get all the time is friend requests on Facebook, or even connection requests on LinkedIn from subordinates to their bosses, or from bosses to their subordinates, or from mid-level people to mid-level people, whatever it is. Well, what's the easy advice? You know, lawyers love to say no, so I say no, don't do it. You know, unless you absolutely have to, it's better off. You don't know what the relationship's going to bring down the road. There's things that you might find out that you don't want to know. For example, let's say the person's a perfectly good worker, doing fine, but has some sort of medical condition that you learn about on some social media page or some other source. If it has nothing to do with work, you never would have heard about it. But now it's out there, and God forbid there's a separation down the road. Perhaps they have an avenue to accuse you of having it based on the medical condition rather than on the merits of the job. So a lot of times we have people who've left the company, and then all of a sudden they're sending nasty things on social media that you wouldn't have been connected on before. You don't need to know, you don't want to know, and then there's issues related to still being connected on these platforms when they're no longer working together. So I don't, obviously my partners and I are connected on LinkedIn and Facebook, but with employees I tend to avoid it unless absolutely necessary, and it's a little bit safer. Now, what you can't do, however, is tell your employees or have a policy that say, hey, you can't connect on social media. You're not permitted to do that. They may be talking about terms and conditions of employment. So the best is to stay as removed as possible from that experience. It may be hard. You may have someone say, be very insulted that you don't want to be connected with them and see pictures of their kids or whatever that is. We had a program yesterday with local HR folks about employee engagement and retention, which is tricky, very important, very expensive to have to change a lot. And they were and I was noting, I happened to see comic strip. Always read the comics. You've got enough bad news out there. I like to read the comics. So Dilbert had a comic the other day where the pointy-haired boss, if you know Dilbert, the pointy-haired boss goes up to the employee and says, "Hey, how you doing? How's the kids? How's your spouse?" And the employee's like, "I've been here 20 years, I'm not married, I have no kids." So the pointy-haired boss walks away, and the employee turns to somebody else and says, "Somebody went to employee retention training yesterday." So yes, that can be awkward. People want to talk about their kids and their life, and Johnny scored a goal in soccer yesterday, fabulous, congratulations. But that's the risky part of it, and we want to be engaged with folks, but we don't want to be too engaged with folks, and it's tricky. If, God forbid, you are interacting online, obviously be careful. That's not the time for reviews of their performance or their demeanor with customers. And like I said, of course, it's never, everybody thinks it's gone, but it's never gone. And of course, discussions about unions. So let's say you're a non-union shop and there's any sort of discussion about possibly going union, that's protected for them. So got to be careful about that. So there is an exception to this. Like all rotten lawyers, we always have a gray area. We have maybe yes, maybe no. Sorry about that. And one of those is bullying. So yes, there's a line that can be crossed. You can have a general policy that we don't permit bullying or any illegal discrimination or harassment based on age, race, sex, all the protected categories. And in fact, for many years, I think almost a decade now, there's been a bill in Albany passed by the Assembly and not passed by the Senate every single year, prohibiting bullying. Now the pros and cons of that, I'm not a political activist on either side. The Democrats are promoting the bill and that, hey, bullying is bad, it's inefficient, hurts the workplace, and sometimes it's not based on any protected category, so it's not illegal, but it's a bad thing for the victim and it hurts the company. The Republican counter-argument to that is, oh my God, we got enough lawyers and lawsuits already. If we prohibit bullying, then every single unhappy employee would have a potential lawsuit, a potential claim. It might be a Division of Human Rights claim. But every time you were unhappy, now at least you have to fit into a protected category argument. If they pass that, everybody could come, I was bullied. Every time, everybody who got fired could say it. So it's tough. But so your general policies and you can have some common sense in your workplace about bullying beyond discussion of wages and hours and terms and conditions of employment. So that I can't describe every thin line between those two, but that's you should know that's out there. Another exception to the general rule that the folks are allowed to talk amongst themselves about terms and conditions, they can't go out there in the media and say, hey, I work at XYZ Corporation and on behalf of them, here's my position on something. They can't speak on behalf of the employer. You can prohibit that. And I guess that's, you can't well prohibit them from talking, but they can't talk on behalf of you. You can prohibit that. So you can prohibit them from talking on your behalf, but you can't prohibit them just from talking to the media or the government about their own concerns. They can say, I don't like the wages and hours, I don't like the terms and conditions. You can't stop them from doing that. You can only stop them from speaking on your behalf. And that includes both media and government, and even for customers. You can say, listen, your job is X, you do not have authority to buy a $50,000 machine, you don't have authority to talk to customers and sell them this or not sell them this. That you can do, but you can't stop them from talking to anyone about protected terms and conditions of employment. Another illegal clause or a dangerous clause is that if you have a general policy about disclosing confidential information and then try to order employees to report on each other, you can't do that again if it implicates any term or condition of employment. And as for any of you who've had union training or been in a union situation, one of the very dangerous mistakes that employers make is any sort of surveillance of a union or of people talking about forming a union or anything like that at all, including if there's a group of employees after work talking about possibly joining a union and you go and park in the parking lot. Even things as simple as that can be serious violations, so you got to be careful on that. That's also illegal. On the other side, things that are lawful that you are allowed to do, we covered a couple of these: trade secrets and processes and protectable data, how you do your work, what your company does, things about how your company delivers services that are not public. You can keep that quiet. Prohibit bullying. Prohibit posting in another's name. That's surprisingly common and very disturbing for a very weak computer savvy IT type person like myself and most of us lawyers. But there's quite a bit of that where people will go on social media, get someone else's account, hack into each other's account, and post things in other people's name. You can certainly do that. And this is sort of related to what I said before, that they can't speak on your behalf. They can't say, this company's opinion is X when it's not. You can prohibit them from talking on your behalf when you're the company. And requesting employees to be respectful of each other, yes, that's legal. It's underlined because it's a very dangerous one. So certainly my example in the beginning of it, Keneally and Russell stink and Underberg and Kessler doesn't pay enough, that's certainly not respectful, but it's legal. So you can request it, but it's a case-by-case analysis of of the line between protected and respectful, and you can guarantee the NLRA allows some disrespect towards their goal of letting employees talk about terms and conditions. Other clauses that are lawful, that are allowed, requesting them to be accurate and truthful. Again, another somewhat gray area, employees' opinion or exaggeration of what's fair or not fair about pay or benefits is one thing. But if they out and out lie, that's different. If they say, they pay me $1 an hour, and they should pay me the minimum wage, and that's a lie, you can take action against them for that. And sometimes that happens, where they just flat out make stuff up, just to try to prove their point. So that's different. This is a very, very tricky one, and a huge problem for many of us, I'm sure some of you, is the use of social media while working. So there's first of all, they're all doing it, just in case you're wondering. They are definitely doing it. And the question is how much and when. So obviously, we all have in New York a half-hour meal break that's mandatory. So you cannot prohibit them from using social media on their half-hour meal break. They're not to do any work during that half hour, and that's fine. But what you'll see, of course, I'm sure if you look carefully at your company, is people doing their work, and then they get a text, boom, they get a post on Facebook, they get a post here, and they're back and forth. And some people are quite productive doing that. They're able to accomplish all their duties, despite this distraction. Other people can't, and the reason that they're not very good workers is because of that. So yes, you can prohibit it, but I think it's a little bit of a slippery slope, more on the practical side than the law side. I think if you really enforced it, you'd probably have a revolution on your hands, particularly among staff. But you can do it, so that I leave it to you to try to manage that. But it's, like I said, those few cases where we've had feedback on how much social media is actually used during a workday, it's astounding. It would knock your socks off. Like, you just can't believe they could do any work and still do all that. But of course, they could say that to me, that somehow, I'm tracking, 3 playoff baseball games in the middle of providing legal advice, or, if the Masters is on, I don't really miss, I got one screen on the Masters and one screen on my email, so, nobody's, don't throw stones all the time.
Paul, question. Yeah, I just wanted to follow up on if a company is prohibiting social media or limiting social media, have you had any experience where they come to you and say, I want to monitor, I want to see how much social media they're doing?
Yeah.
And what do you advise them on a situation like that about what type of rights they have or not?
Yeah, that's a great question. I mean, the first thing I would say is be careful what you wish for. You find out stuff you don't know. But yeah, technically, and you probably should have this in writing, if all of the devices that you're talking about are the property of the company, then you're certainly entitled to review those devices. So certainly anything on the computer that's your computer, if you provide the laptop or provide the desktop computer, if you provide the phone, if it's their phone, you can't go in there and search it. But you can say you can't use it while you're working. You can only use it during breaks or in real time. So generally, employers do have relatively wide latitude to, look on the network and search through it, and we've done it in many, many cases. But I usually say, folks, let's have a reason. Let's not just do it because the employees won't like it. Question.
Is there a fine line between providing employee a phone, but they are permitted to use it for personal use? Like, that's their one phone.
Yeah.
A lot of guys we have out in the field, that's their one phone.
Sure. And what I advise on that is, again, on a case-by-case basis, is really be mindful of what you're doing and why you're doing it. So so let's say, obviously, a great example today is the sexual harassment issue. So let's say we have an allegation that somebody's using their phone that you provided to sexually harass another employee. You have a duty to protect that victim, if indeed it is a victim, so we're investigating. And one of the tools may be to search through that device that you provided, and I very strongly think you should give notice beforehand in your employee handbook, hey, anything that's our property, we are entitled to go through it, and we might do it if we need to. And that was an example where I would absolutely do it. And arguably I have to do it to protect that victim. Another question.
What if you get a stipend for a phone, but it's not the company's phone?
Yeah, that's tricky. So the stipend just pays the monthly fee, but the phone belongs to the employee. So very, very interesting topic. We could do like 4 hours on that alone. But the big thing, the way that the twist on that often is the employee does work on that device and they hook into your network. So again, the policy in your employee handbook would say any device that hooks into our network, we are entitled to review. So when you went in there, I would be looking only at business things, so work-related emails and spreadsheets, and then, God forbid, in my sexual harassment example, anything that was between the victim and this person, if I was searching their device. But I often write in the employee handbook up front that, to the extent allowed by law, any device that we've provided or any device that utilizes our network for work, we're entitled to look through. And a lot of these issues don't get fully resolved. We don't get a decision from the judge in the end, but so we do use our best judgment along the way. But I can tell you, if it turns out that person is in fact sexually harassing someone, they're not going to get very far crying to the judge that, oh, they looked through my device when they're sending nasty stuff around. So, questions?
In terms of prohibiting social media use, can that be case by case? Like, say somebody's on, or does it have to be policy for the whole company?
That's a great question. So the answer is you're not required to be perfectly consistent. So we get that a lot. So I get that a lot. Oh, employment lawyer, well, this person's having a lot of trouble, so I know I can't be tougher on him or her than everybody else because I have to be perfectly consistent. You don't have to be perfectly consistent. You just can't be inconsistent on an improper basis, like age, race, sex, etc. So in that example, if you have one person who's struggling to get their job done, everybody else uses social media during the day but gets their job done, but one person doesn't, you could say, listen, I'm going to be enforcing this rule, which does apply to everyone, but I'm enforcing it more to you because you're having performance problems and they're not. That's totally legal. Now, politically, that's a different question, and you're better at that than me. But legally, that's absolutely fine. They have a performance issue, and you're trying to fix it. You know, and certainly another thing that is wise on your behalf is to warn employees that they're going to have problems of their own, depending on what they're saying out there on social media. Defamation, and we've had more and more of those cases over time. Not the easiest case to win, but certainly some employee doesn't want to pay a bunch of legal fees to defend themselves. And you know, harassment claims against them, where they think they're just complaining about a coworker's performance, but it leaks into something on a protected category basis. And God forbid the bullying comes. So these cases are not that recent anymore, but all are still in effect. You know, that you can see that the NLRB, you know, is falling on the side of the worker very often. They found they were criticizing other employees, but it related to their own job. Hey, those 3 guys are really lazy, so I have to do extra work. It sounds like bullying. It sounds like something you shouldn't be allowed to do, but it's about their own terms and conditions. You know, commenting or liking coworkers' posts is protected activity. Confidentiality agreements from disclosing all allegedly non-public information, personnel lists, personal information, home address. That can be risky if you get too broad on this definition and it gets into terms and conditions of employment. Prohibiting people from giving out home phone numbers of their coworkers, that's okay. But some of the other stuff, you know, the fact of whether somebody works there or not, the NLRB found that was too restrictive and too close to prohibiting them from talking to each other about these type of issues. And the non-disparagement clause, which said, hey, basically said, hey, you can't say anything bad about the company, that's illegal. Because they're allowed to say something bad about the company, depending on what they say. Let me know on the time.
Sure.
Now here's a case that did go the other way. BMW dealership. This guy posted a video of this terrible accident and was making fun of it, and you know, it was not concerted activity. It was not about terms and conditions of employment. It was just gratuitous, nasty. You know, he obviously was mad at the company about whatever, but that was not protected. The employee's lawyer after the fact tried to say, oh, I was criticizing the marketing event. It wasn't, you know, this was legitimate terms and conditions, and the NLRB said, no, that's too much. This was not protected this is not legitimate activity. This was just a guy being a jerk. So, you know, there's a line, there's argument in these cases. You don't necessarily want to have your company up there in the NLRB decision and having all that expense to fight it out, but, you know, there are reasonable limits to these things. So what are the action items? What can we do going forward? Try not to be vague or overly broad in your language about social media use in your employee handbook. You know, try not to write something, you know, overly comprehensive that gets that could possibly get into wages, benefits. And this one's tough. Don't encourage employees to turn in each other or infer that you're watching posts. So we have good questions about in the context of an investigation or an issue, looking at social media or looking at the devices and looking at your network. That's one thing. But to let out there, oh, we're watching everything at all times, just proactively, I don't think that's a good idea, and the NLRB would definitely not like that. And if you're talking about confidential or protected information you want to protect, be specific about it and talk to us as you're writing it. Tell me about your business, it takes 5 minutes, and tell me the things you want to protect, and I'll say, good, 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 no, that one's not, you know, that's generally known. I mean, we have all these examples of these great tech companies, and they go to these seminars or these industry events, and they brag about their cool technology, and they describe it in great detail to their colleagues and to the world, and then they go home to their company and say, that's all protected, you can't tell anybody about that. So be careful about that. I can't tell you how many cases. Trade secrets are hard. Trade secrets got to be secret, like really, really secret. And again, it applies to us in non-unionized workforce. And so let me talk a little bit about just the new sexual harassment very quickly. So social media harassment is very much covered, very much something that you have to protect your employees who complain from. We all have to do this new training, and there's a specific manual, a specific form of what the training has to be that we've done a bunch of times already. They just changed it, has to be by October of next year. The new anti-harassment policy must be in place by 2 days ago. So if you didn't do it, please do it. If you're not sure what the hell he's talking about, please call me and I will fix that for you. Problems with content seems to be gone, but gone, it's never gone.
Is that true for any size company?
Yeah, if you have one or more employees. Yeah. They really gave us a break. If you have less than one employee, you don't need one. That's nice of them. The good news on that is you don't have to be omnipotent. You only have to fix what you know about. But this training and these you have to give out a complaint form now. But we can only fix what we know about. But you have to make an effort to know about it. Even the slightest notice, if a victim makes just the slightest comment on the side to a manager that, hey, John is creeping me out with his comments, that triggers a full duty to investigate. And it seems like she didn't barely mention it. Unfortunately, that's the law. Yeah. Oh, question.
The behavior out of the office may still trigger liability.
Yeah.
Like,
I'm with you. I'm with you. It's a huge, huge problem. So the easy example is 5 o'clock, hey, we're going to Charlie's to have drinks. I'm paying as the partner, company's buying, we're going 5 to 9. Unfortunately, sometimes it goes 5 to 1 in the morning and I'm still paying, I'm still hanging around, not good. And that's a company event. Any sexual harassment in that, you're absolutely done. And then there's gray areas, What I advise all my clients is yes, great, go from 5 to 7, pay the tab and get the hell out of there. And then whatever happens 7, whatever, hopefully will be just amongst the employees. But if it has any sort of carryover into the office, so there's some conversation the night before at a non-company event, and then it's brought up the next morning in the office, they all get lumped in together. So it's a case-by-case thing, but I can tell you, I'm talking, if my brother were, a young employee or my kids, I'm like, it's all work, be careful. Do not have, no loose comments, no nothing. And our duty to investigate, it doesn't end there. Conventions are the worst thing in the world. I got more sexual harassment claims on overnight business conventions than any other situation ever. People seem to lose their mind. They're not coming home to their own house. It's absolutely
finds its way back in.
And it always finds its way back in. That's exactly right. So it's a very, very difficult situation. I hate, as soon as I hear convention, I know where it's
Paul, you look handsome in this topic.
That is okay. First of all, it's about me, so it's cool. But I can tell you, I'll give you.
It could be harassment.
It could be. It would never. I mean, it's a great question. It's never harassment by itself. There is some limit to the law. That is not harassment. However, I'll give you a great case. Okay, I'm going to use U5 as an example. So, true story. 5 years ago, I'm the big boss. I'm the CEO. My office is over there. Every morning, 8 o'clock, I come in. Oh, that's a great dress you have on today. Hi. Hey, how you doing? Oh, awesome skirt today. Hi, how you doing? The next day, you got the nice clothes and you got the nice clothes instead of that. Every day at 8:15, like 3 of them would stand up, and it was all women, I'd say, and he was a man. 3 of them would run up and run to the back. Oh my God, he didn't like my outfit today. He didn't like my makeup. Oh my God. They were, and I met these women. We had a full lawsuit. They were freaked out. They dreaded 8 a.m. every single day. And it was nothing more than that. I've known the guy for 20 years. He's not a bad, I know bad guys. He is not a bad guy. He's an idiot, but he's not a bad guy. They were generally, the youngest one of the bunch, and she needed therapy. She was freaked out by that. And I totally, and I couldn't appreciate it, because obviously I'm not much of a dresser, but I felt for her. I mean, I really empathized when she told me this, and we stopped it, and it worked out. But, so, those innocent things can be part of a bigger thing, and guess what? Taking another case, bad guys like to start slow and inch their foot into that. So they do a lot of neutral ones and then see how far they can go and how far they can get away with it. So, the software to detect inappropriate conduct is absolutely allowed, by the way. Had a very good idea, very cheap, and we have it. Everybody should have it. So, is that it for me? All right, you're up. One more question.
What was the software you said the very last?
Oh, sorry, I went really quick. So there is tons of software out there that you can install on your network that will find inappropriate conduct. And so the funny thing, of course, is given what I do, about twice a month, the IT kind of guy comes in and goes, Paul, I go, dude, it's a case. I promise you it's a case. But we do it. And then I pull it up and I show that it was an email attachment of some poor unfortunate pig who was doing what he shouldn't do, whatever, and that's it. But we do that, and unfortunately, I've had clients who, discovered that Johnny is watching porn all day long and he needs to be fired. So I would encourage you to look into that. One more question.
Just real quick, this whole thing about filing a complaint form,
Mm-hmm.
does that, I don't know how it works in detail, but would that actually deter someone from coming forward and saying, because sometimes what will happen is, okay, I'm telling you this happened, but I don't want you to do anything
I'm
about
sorry, I'm
it.
taking
Yeah,
your time.
I want you to
That's a
do
great
that.
question, and it's a very easy solution. It sounds weird. The first thing you say is, you breathed a complaint, so I'm sorry, I can't keep it confidential, I can't help you, I have to protect you and everybody else here. I'm doing a full-blown investigation, and I'm sorry, but you can't put the egg back together, I'm sorry. And you just tell them, it's not confidential fully, and I'll keep it to who needs to know, but I got a bigger duty than you, and I'm sorry that you said it. And the problem is, they say it to their manager who's a friend,
Right.
and they want to be a friend. You're not their friend, you're a manager. And it's the word, because usually it's true. Like somebody said, that's probably a pretty credible complaint if they're saying, oh my God, I hate this guy, he's harassing me, but don't tell anybody, don't investigate. You gotta investigate, it's easy.
Okay.
All right, thanks, Paul. Thanks very much. My name's Ed Russell. I chair the corporate group at Underberg, and I'll call it kind of the boring group because, Paul, what happens in our office is you want to get a deal done, everyone's in a great mood, everyone wants to have it happen, and they call me up in my department, and we help get that deal done, closed, and everyone's happy. What happens with Paul's group is, in litigation, they get the phone calls with the crazy stories. So that's why Paul's is always the more entertaining for his, because he can tell you all the war stories and the horror stories that happen and the crazy stuff. But I wanted to do two things in my presentation. One, just sort of talk about the benefits of social media, and then some of the issues to avoid, pitfalls, depending on your business. And one of the difficulties with this is every business is going to use social media differently. And so in this context here, you're going to look at this and this, like for example, promotions. You might not do promotions, but these are some of the ways you can use social media, boosting your brand awareness. I think all of us can boost that. Interactive customer support, employee engagement's a big one, and I think more and more businesses are using social media to actually do internal as opposed to external marketing. And then hiring and recruiting is another area, is a great way that you can use that tool. And one of the things I think a lot of people, I guess I'll quickly look around, I assume everyone here is familiar with LinkedIn and probably uses LinkedIn. I use it myself. But one of the issues with LinkedIn or any of these programs is we're probably not utilizing them to their full potential. I think, I'll give the chamber, I think, is one. They're very tech savvy, social, using the social networks. Chambers are very good at that. Most businesses are not, and they're not utilizing it. And so I'm going to probably assume that a lot of you are not utilizing social media. And I'm going to turn that microscope back on myself. Specifically, just before I gave this I was talking about this to my kids last night, two 11-year-old twins, and they were really interested because they saw social media, and usually the stuff Dad talks about is so boring. But social media, wow, and one of the things they looked at my program, the first thing they noticed was Snapchat was not listed as one of the social media. I'm like, are you kidding me? But what was interesting was my son is looking at this and talking about it and said, Dad, you use LinkedIn, right? That's what you business people use. I said, yeah, we use LinkedIn. Oh, okay, so you push that out. And push what out? You're giving a presentation tomorrow. Yeah, so you push that out. I'm like, what is he pushing? And I'm like, I realize what he's talking about. And no, I did not do this. I did not put it on my LinkedIn page that I was talking today. But it's like one of those things where we have so many things going on that we're not realizing and not utilizing our social media to the full advantage. And so one of the things that our firm is doing, and I think a lot of firms should be doing, is looking at within your own group, who's helping you put together your social media plan, who's helping you push your brand, your name, your recognition, your employee stories, your hiring and recruiting out to the network. And one of the things we're doing is actually hiring a consultant to help with that. And I think a lot of businesses could use a consultant to come in and really, because the landscape is always changing, unfortunately, and it's going to be very tough for us, I won't call myself a dinosaur, but really a dinosaur in this world, to keep up. So that's one thing I'll notice, that a lot of the companies that I work with and talk with just have trouble keeping up with that. So that's one of the areas that social media is just a tool that can be used, but I don't think we're using it effectively. So here are the advantages. Very inexpensive. Typically, you can set them up much more than a web page. Now web pages are much cheaper, and I remember at the beginning, web pages were very expensive, and the nice thing about social media, very inexpensive. So it's one way to, I talk with a lot of startups. People who just want, I want to start a catering business, I want to start a coffee shop, I want to start whatever it is, and how do I get my name out there? And what are the first things, Facebook, one of those things you can do really easily, inexpensive, and get your name out real quick. So that's one area that is very beneficial for people. It's informal, real time, easily customizable. I still know a lot of people who have the web pages that call me up and say, we set this web page up 10 years, we can't do anything with it. I don't even know, I don't know what to do. So that's one of the other benefits where your web pages, I think, have become much easier, but that's another area. And then you can have interaction with your customers, a little more informal way to interact with your customers. So I think that's another benefit for social media. But some of the risks associated. So you have something that's a little less formal. But what are the problems with it? A lot of times I'll get a phone call from a client saying to me that we just posted something erroneously, like misleading advertising, misstatement or omission. And what do? Well, fix it. Go out there and fix it immediately. And if you get a phone call about that, address it and be forthright. I think one of the biggest issues, and I think one of the slides will come up about this, is they have a tendency to be like, you know what, we posted something that was erroneous, we'll just wait to see if anyone notices. If no one notices, I won't say anything about it. Well, it's just that you're leading yourself, be upfront, address it, and maybe no one will ever notice it, or I didn't even realize you did that. But they feel like if I call attention to something, I'm going to be doing more damage to myself. Call your attorney first to talk about that, but most of the time it's not, and it's probably better for you. You're avoiding trouble down the road. Posting content owned or controlled by someone other than your company. So this is where the ease of it can get you into trouble. I had a client once post a video clip that they had made, but they used it of The Simpsons. Well, guess what? They got a phone call from a firm in California who was not so happy that they had posted on their webpage something about The Simpsons, even though it was a short, 5-second clip or something like that, that was available on I forget what platform they were using for social media. But they wanted a cease and desist, and they also wanted damages, which we said we're not going to do that. We'll remove it, and in this type of network, you don't need to worry about damages. I mean, typically they won't go after you for something as small as this. But that's where your employees who are doing this, if they're not well versed, they might not understand. It's like, but I created this, but it's not your content. But I cut it. It doesn't matter. It is not your. You have to be very careful about that. And so, yeah, go ahead.
What if it's something not as big or trademarked like The Simpsons? So
Right.
what if what if your company's mentioned in a newspaper article?
Right.
You can't copy paste obviously and just take it as your own.
Mm-hmm.
So if you give credit to or just do the link,
Yep. That is
assuming
right.
that's okay.
Yes.
So I had a situation last week where somebody who I don't know
Mhm.
sent me a list and said, we see that you guys do a lot of sustainable design work. we have links to all these different sustainable articles, would you share them on your website and your social media? Can I do that? I mean, as long as they give me implied
If they're giving permission, but then the issue is what they provided to you and you're linking, is that, where did they get that material? So it's a kind of a rabbit hole of where this comes from.
So we'd have to have permission from each person from each one
Yep.
of those.
Or you make sure that they're going to indemnify you if something that you then pull in is not already copyrighted or trademarked already.
Right.
So it becomes very, and at the end of the day, a lot of this people, it comes down to whether or not there's damage done by doing that. Most of the time what you get is a cease and desist letter and you're done. So, you know, if you post something that's inaccurate, or if you post something that's someone else's, they notify you, cease and desist, and you correct it. The real problem is if you made if there were some damages related to that, so that's where the issue comes up.
What about intranet sites, so just internal things? I know in the training world, a lot of times people will use other people's content, especially video clips and that type of stuff.
Right,
So it's
right.
not going to the public per se, but just to the business, is that an issue?
That's less of an issue because you're not going out and trying to promote, you're not using someone else's material to promote your own business. You're doing it internally. Still could be used, but you know, it's internal, it's less of an issue there and less likely that they're gonna get upset about something like that, so.
And that's my role, and I always make sure to tell my team that they're always posting where they got it from.
Exactly.
Right.
So if you're gonna use a video, because we
Yeah.
use a lot of like Pixar videos
You
and
too.
things, and it's always make sure you're putting it in there, that it's theirs.
Yeah.
So I had a situation once with a not-for-profit, probably not-for-profit, they don't have a lot of funds, so they kind of, you know, they kind of patch things together as they can, the best they can. And so they wanted to create their own logo. That's great. They created their own logo, they posted it, and then we got a cease and desist letter. Because the logo they created was someone else's that they really created this, I believe, on their own, but it was so similar and so much like someone else's from, I forget where it was in the US, that, so those things will happen.
Yeah.
Just to be aware of them. You can't protect yourself from everything like that, but just be aware that with this digital age, everything is out there, and so they're more likely that something's going to get pulled in by accident. And just be aware and let your employees know that. And really, you should be vetting of whatever goes on. Someone, you know, if someone's posting, someone should be watching that. There should always be a second person reviewing what's going on, what's happening on your social media websites. Collection and use of certain consumer information through interaction with social media, privacy laws. So that's where you might be doing a survey and you're pulling that information in. You got to be very careful about those things. Really use a third party to do your surveys because if you're doing it yourself and you're collecting sensitive information, that could be a real problem, especially if your systems ever get hacked. And then you have a duty to go out and find out, and then maybe you're going to have to pay for some type of credit monitoring or some service out there. So really that's an area that try not to collect personal data on the social media websites or social media sites. Credibility, that your company is judged by your accuracy and willingness to recognize and fix mistakes. I think I talked a little bit about this, and you know the idea here is the business owner doesn't want to draw an issue that maybe not an issue. The other hand is if you try to cover things up, that looks a lot worse. And it seems like common sense, you know, they always talk about the cover-up's worse than the crime, but it's just human nature. You don't want to draw attention to something that might have gone wrong. People like to think that they don't make mistakes, but you do, and you don't draw attention. But 9 times out of 10, if you don't, the issue is going to get worse. So please, if you post something in error, just correct it, make a note of it, make a correction, and maybe no one will notice, but now there are certain instances where that might be dangerous, and you might want to talk to your attorney before doing that. But in general, I will say that more times than not, they'll have said, oh, I didn't do this, the customer asked about this, and I told them it wasn't available, or you know, basically said, no, that's not there, and then they were able to pull up, because the problem here is everything is discoverable. They were able to pull up the original post, and then they started a whole firestorm where you know they started posting negative things online. So you know it's just one of those issues where it's better to try to correct it versus cover it up. Respectful, I think Paul already mentioned a lot of this, being respectful with regards to this. And when in doubt, always ask someone for their opinion about something. You know what you know, you're gonna come from one perspective, someone else is gonna come from another perspective. So just be very careful about that. I know a lot of people hate the idea of everything being done by committee, but in this day and age, whatever you post, if you have one-sided perspective on it, you know, someone else in the company might come in and say, I can't believe you put that up there. That you know, you're totally being insensitive to this way area. So there are some good circumstances where you do want to get some feedback from other people. Policies, and I don't think, Paul, we addressed this, but I get a lot of times where they say, we don't have a policy covering our social media. You can have a policy on your social media, but if you still have other policies, code of conduct, they apply to social media. And I don't know why people seem to think, if you have overarching policies, they cover every aspect of the business. But a lot of times I'll have someone say, oh, we don't have a social media policy and they did X so on the social media website, so I guess we can't do anything about that. No, you can. The policies apply. And please remind your employees that whatever policies you have cover their use of social media as well. So that's one thing that comes up a lot, that they're not aware of the policies and they start doing things on social media and they think that they won't apply because they don't have a specific social media policy. You don't need to have one. Paul, do we have a form social media policy?
We sure do.
Okay.
Yeah, absolutely.
So you can't put one
Underberg
together.
Kessler has an outstanding social.
So, but I mean, that's one of the areas where a lot of people think if you don't have one, it's not covered, but it is. Any of your other policies cover the social media, so they have to be aware of that. Talked about that. I think Paul mentioned a lot of this. Don't harass or discriminate against fellow employees, and of course, don't do false or misleading endorsements. For example, claiming to be someone other than yourself to create buzz around the company or its product services, or failing to identify yourself as a company employee. That's the other big one where, and I will be honest, a lot of businesses do that. So you're going to argue, the business owner will come to me and say, hey, my competitors are doing it. I know that's their employee who's posting those great reviews online. I want to do the same thing. And I'm going to tell you not to do that. At the end of the day, you're running a risk. But that is one area that, these posting of reviews, a lot of them are coming from the company themselves. So or they hired a third party to do all those reviews for them.
How about things on the internet like Glassdoor, when employees, like disgruntled employees
Yes.
who get on and say whatever they want, even lies
Yes.
about your company?
Yes.
Is there some reciprocal one for business?
Okay, so we'll talk about confidential information, but there's a slide that comes up to talk about this, but that is a big issue. So it used to be, I would get a phone call and they had said, disgruntled employee is slamming us on social media. Usually at the time it was Facebook. What can we do? And it used to be almost no recourse. I mean, it was a black hole. Because I think at the time Facebook thought that they were going to create this great utopian society and we'd never have any bad reviews and everyone would love each other and we didn't need to worry about it. So why would you ever need to take something off Facebook? Now we all know that that's not true. For example, I think it's Google allows you, or I can't remember one of them, actually those three little dots on the side, if you see a review that you think is suspect, you can click on it and I believe it allows you now to flag it as a suspect. Doesn't mean Google will necessarily take it down, but at least it's now a process. And there are now, they all have codes of conduct. And if you think that something is violating, Facebook's code of conduct, you can bring that up to Facebook and address it. However, at the time when I was doing this about 5 or 6 years ago, those issues were coming up all the time. People were lying, and they were like, I want to sue, I want to stop them, I want an injunction. And those are all great options. Very expensive. Law firms will cost lots of money if you start going out there and suing everyone who writes something negative on that you think is untrue. But the reality is you're not going to get very far. And the best way to counter them is to basically address those right online. So basically go back, be respectful, but go back and post or have an employee who's having a great time, or a former, you have alumni who maybe worked at your firm and moved on to another job, post something back. Reach out to them and say, we're getting these on Glassdoor, we're getting these negative reviews. Ask them to post something positive about that. So what you do is the way that most firms are now doing that is you get in front of it by putting more and more positive posts and becoming a strong advocate for your own company. not necessarily going after this person as a dirtbag that it might be, but you go back with your own positive, and that's how they're countering it. But there are some options now with regards to if something is really outlandish, being able to address the social media provider themselves directly if they're in violation of their own policies.
2 points that I think are really important for that are, one is the company has to be really careful of not pressuring their current team members to post positive stuff, because that also comes up really prevalent in Glassdoor. And as a company, Glassdoor, you can reach out to Glassdoor as well, and they will do kind of like an investigation as well to see whether or not what is and what is not fake and or incorrect or lies, and they try to work to assist the disgruntled individual poster as well as the company too.
But that process can take a while,
It does.
and so the best thing to do is start getting the positive reviews out there if you
Yeah.
can. But yeah, be very careful with your employees that you're not going to feel pressure to do something like that. But yeah, that is a real big issue. Fortunately, I think they've come around to realize that the social media has been a tool used negatively as opposed to positively, and so they're trying to address that now. But it's still an issue.
Even if you can't put your name to something, I mean, if you're gonna make a comment and you're not gonna put your name to it. And
Right. And that's the biggest issue. So.
Yeah.
Confidential information, I think we talked a little bit about this, and as Paul mentioned, be very specific with your employees, what is confidential, what is not. Because they're not going to understand. I mean, a lot of these times, they're not gonna understand because it's talked about in the business all the time, within that realm, and so they forget, or they're not realizing, or not thinking. So be very explicit about, every time you bring up the subject, let's say it's a client list or something like that, this is confidential. And to you might be, of course the client list is confidential. It's not. It's people who, you might have a new hire who's posting on your webpage who doesn't understand that. Let them know about these issues. And sometimes your own customers, you get a great review. You'll sit in a room, and the head of the business owner will tell what a great success story we just had. And then the person who is in charge of social media says, I'm gonna post about this great new success story we just had, and that was not supposed to be made public. So you think, well, it's a great success story, I want to promote that. You go through the talk to people and let them know that, yes, this is confidential, this is more for us internally as opposed to externally about what's going to go on in the realm. And of course, don't comment about rumors. Best way is just say no comment. Social media accounts, we talked a little bit about this. All of this, like login information, the passwords, all of that, if it's created or used by the companies, it's the company. So, and also any content associated with each account. So what happens a lot of times is the individual sets up the account for the company, but then starts using it for some personal or might just friends, say letting them know, and there's some personal information on there. All of that becomes part of the company. So if it's a company Facebook page, the company LinkedIn page, those don't belong to the employee who might have populated it. It belongs to the company. Personal use of social media. This is one area that it's coming up more and more, and you'll see that. And Paul mentioned about this, that it's very hard to necessarily monitor, but it's hard to control. So you might have a policy that says ban it completely. I think that's an unrealistic policy. Instead, you should put limits on it. And I think that's a better policy to have for your company. Because if you ban it completely and one person is not using social media and the other person down the hall, they know they are using it and you're not disciplining them, that creates a real bad culture within the community. So try to be very careful about how your policies will impact and how you're going to implement your policies as well in social media. Because if you're allowing one person to use social media one way and another person you're not, that can create real concerns within the culture of the firm and will deteriorate over time. I think a lot of this is pretty self-explanatory. I mean, one of the things that you'll see a lot in emails, and I think a lot of people have moved away from it, is Johnny's selling popcorn for Boy Scouts. Will anyone using the firm platform to do stuff other than firm-related stuff, and you want to move away from that, and that's the same on the social media website. You do not want your employees using them to, even though they might be for a good cause, the problem here is, again, every employee might have a kid. And do you want that on your social media's website? Do you want that, just, it's a better to be consistent with it and just say, we can't do that, we just don't allow something like that. And again, remind them that there's no privacy at the office. If they're using the company's resources, you know, I will, especially, you know, not only just social media, but emails. A lot of people who use social media or use their email, their work email for personal stuff. You know, most of the time it's okay, but which they start doing it and then they forget. I had a situation once where, and this was actually a matrimonial case, where I wasn't handling, but the person was sending emails from the school district website complaining about his relations, and guess what? He's no longer at that school. So those type of issues, that, you know, just because you're using your work email for personal, that's okay, but remember in the back, remind your employees that they really should be having a separate email account that they should use instead of using a firm email. All right, that was all that I had, so I just wanted to check to see if there are any questions or follow-ups with anything or with Paul talked about. So. Yes?
Hi, I'm actually here because I work with young people, minors that are in the workforce, and we're trying to teach them better digital citizenship in general. But I think it was the first half of the presentation, I'm wondering, it may be unique to minors in some of their social situations, but I have a good friend from school, where we get along really well, things are good, we end up at the same workplace.
Yep.
And something goes bad, and now I'm posting on social media about my friend,
Right.
slash now enemy. Maybe or maybe not referencing things at work. Does that mean that's considered essentially workplace harassment?
Well, that's a good question. That's like a law school final exam. There's like 4 questions in there. But so if you're advising that person, you know, if that were my sister or my niece or something, I'd say, don't do that.
Right.
Take a crazy risk. Do not do that. Don't mix personal. In terms of the company, it depends. We would have to really go through every word of that. If it's all related to terms and conditions of employment, that, oh, we used to be friends, we're not friends anymore, and we have to work with each other, and the boss won't let me go to a different department, that's all protected. If it's just merely, we used to be friends and now I hate her, that's not protected, so she could be disciplined. So it's crazy, the word for word we do on this stuff, but that's what the law requires us for now.
Just no, just don't.
Yeah, exactly. I mean, certainly talking to my kids, I'm like, don't do it, just don't do it.
Thanks.
It really works, by the way.
I know.
Yes?
Now, sometime about social media, you know, we were talking about good review or bad reviews.
Yes.
It's not for employee. But sometimes, you know, they give you incentive to get good reviews. Like if you get good reviews, you get $5 discount or 5% discount or something. You know what I'm saying?
Good reviews on your social media.
So you're giving a
postings?
potential customer?
Yeah, kind of.
Okay.
Customer, or could be just break for your own services afterward. How ethical is it?
Yeah, that's there's nothing wrong with
Yeah.
that.
Nothing wrong?
No, there's all sorts of creative ways to compensate folks, sales or otherwise, or marketing. That's absolutely fine. I've heard more about that lately than before, about companies actually rewarding folks who are better at social media on behalf of themselves or the company.
Probably one of the better ways to do it would be, fast food. My kids love getting free stuff. So whenever we go to like McDonald's, there's always, if you fill this out and put in a code, you get a free drink next time you come. They love doing that, and they post a review. But they don't, McDonald's or Burger King doesn't say on there, post a positive review and you get a free drink. You just say, post a review. Post a review and you get something. Well, most likely, if you're getting something free, you're probably gonna say something nice anyway. So there are ways around that you can do it so it's less looking like it was a basically paid ad. So, yep. Anything else? Yes.
From a new business perspective, our company is asked us to share our LinkedIn contacts.
What's that?
for a new business effort, our
Mhm.
company has asked folks to submit their LinkedIn content,
Mm-hmm.
contacts. Any thoughts on that? I mean, who then owns it and what happens to that?
Well, it's all LinkedIn. So once you put your stuff on LinkedIn, it's out there for the public. You basically, when you've done that, you put whatever you put on LinkedIn, and then someone else links to that. There are restrictions you can build in, but in general, anything that's out there, you basically you've given permission over. You've granted it over. So even if you put restrictions in and they're somehow able to get that information out, you've given a lot of that over. So.
Yeah, it's one of those things that you can, by contract, if you will, your company could say, hey, any sort of customer list that you develop or any contacts that you develop over time or that you're employed by us, or even things that you had before that you now use when you're employed by us, we're paying you now, they become our property. That's actually fairly enforceable. So the extent of who owns it, yeah, it could well be that the company owns it if they have the right agreement with you in place. As a practical matter, how much difference does that make down the road? Not that much, because it's a whole nother seminar. But in terms of non-competes, they're not particularly favored. So to the extent if you got another job someday, could you call a contact and talk about business? Probably yes, but depending on the circumstances. I think it's the whole LinkedIn and what Ed said about using your work email for your personal. You just got to make a choice of what you're going to be. For us, I think, we may be a lawyer, but I'm really a salesman. I mean, I'm trying to get business. That's a big part of what I do. So I love how Rochester's such a tiny place. I think it's great for business. So I got LinkedIn, I got everything you can imagine, and we talk about law, we talk about kids' sports, we talk about college, and all mixed in. You make connections, you make contacts. It's all good, but you have to be willing to give up a little privacy for that. So if you wanted to go Google me, you're going to find out everything there is to know, unfortunately, the bad and the good and everything else. So, and some people don't like that very much. Some people don't want to walk into a restaurant and say, oh yeah, that's that guy, I know that guy and his brother, and that's the world we're living in.
Will you be sharing your slides?
Yes, I just sent an email while we were talking. I sent it to my office. Is going to send the program to Susan, and Susan's going to share it with all of you. Is that okay?
Yeah, absolutely.
And please contact us anytime, phone, text, email, anything. We're glad to help.
We want to be mindful of your time.